So if the Supreme Court comes to the conclusion, based on the available fact presented, that Shettima was not qualified as a result of double nomination, right, it will reshape the qualification of Tinubu to become the president of Nigeria.
Issue that comes to mind at this point is the act of non-compliance with the provisions of the Electoral Act. Has this substantially affected the election?
Hello, it's Sasore, and I welcome you back to the show. Ladies and gentlemen, you know we always have it all right here, and today we have another interesting conversation. Yes, today we'll be talking about the presidential election, and for those that are here to listen to our previous episode, the link will be on the description box. Please do well to check it out and subscribe to our channel. So what's your gear now? What's your gear? So, ladies and gentlemen, today I have some interesting guests in the studio with me today. I have my friend Mr. Paul. I also have my friend Mr. Ikpobusa with us today to discuss on this topic. So I will let them introduce themselves. So Mr. Paul, please introduce yourself to our audience.
Thank you, Osas. My name is Omar Paul Enemiku. I am a legal practitioner, practice in Lagos. I've been practicing for over 5 years now, and I'm glad to be here.
Thank you. We are honored to have you. Yes, I also have Mr. Ikpobusa. So Mr. Ikpobusa, please introduce yourself to our audience.
Good day, our listeners. My name is Ikpobusa Peters Aigbe. I'm also a legal practitioner and the head of litigation Neplos Ultra Attorneys. Thank you very much for your time.
Yeah, thank you so much. We are honored to have you here. So we know that the presidential election, that is the 2023 election, was one of the most anticipated elections, and it has not been without drama, issues, and some questions. So today I will want us to talk about the presidential election petition. If you are not aware, after the conclusion of the election, a lot of persons actually had issues with the procedure, and we have been told if you don't agree with the results, go to court. So and a lot of persons or some parties have actually gone to court. So they are in court currently. So we want to discuss on the legal aspect of it as it concerns election petition vis-a-vis the Electoral Act and how it relates to the procedure and the things we saw during the course of the election. I will not be doing this alone. My friends, they will be assisting me in discussing this point. One of the things we saw, if you have gone through the petition by the Labour Party, Peter Obi, you see that one of the issues raised was the issue concerning Bola Ahmed Tinubu past conviction, the validity of him contesting the election as to the fact that there was a fine levied against him in the United States for the sum of $460,000 US.
460, yeah.
Yes, for issues relating to narcotic trafficking. This offense is not just it's not lightweight. So because we understand that for you to contest an election, you must not have been convicted. Am I on track? So
Yes,
I don't know if we can comment on that. So Mr. Paul, what's your take concerning the whole issue with Tinubu's conviction at the United States concerning narcotic trafficking and the like? Does it really have any bearing within our jurisdiction?
Okay, yeah, thank you very much. From where I stand as a legal practitioner, looking at the laws, the Constitution, specifically Section 137 of the Constitution, I'm of the opinion that though it is a very good case, a very good arguable ground for the Labour Party, it may not be a very strong argument to put forward that we disqualify Tinubu, and I'll give you the reasons why I said so.
Okay.
I'm actually an obedient. Even if I have to admit, I'm actually an obedient, but however, I will have to speak dispassionately about the issue. So so it is actually no news that Tinubu was fined the sum of $460,000 relating to narcotic trafficking and all that. There's no doubt about that. In fact, APC has said in their respondents' brief that they actually admitted that yes, he was convicted and all that. No, though they didn't really use the word convicted, but that there was indeed a case like that. Though they have their own argument, surrounding it. But be that as it may, whether it's a conviction, whether it's actually a crime, a fine, and all that, there's something that stands very, very, very sacrosanct. And if you look at section 137 sub 1 paragraph E of the 1999 Constitution, you'll come to find that the issue as to disqualification on the ground of being convicted or sentenced for an offense involving dishonesty has a time frame. There's a time frame to it, right?
Okay.
And the law says that the conviction must be within the last 10 years before the election. So we can begin to merit of the whether it's a conviction, whether it's a fine, whether it's all of that. Yeah. Now, at the end of the day, we have to look at the time frame. The question is, when was this particular case decided on? The question is, when was it? It was decided in 1993. That is 30 years ago, before the conduct of this election. So that alone, to my mind, we work against the Labour Party and Peter Obi, much as I am a fan of Peter Obi. So that alone, it's going to be very, very exactly. It's going to work against them. So even if they succeed in arguing, trying to convince the court that the money forfeited is criminal in nature, it involves dishonesty, which actually looks like it. It looks like it. However, when you now consider the law, it's almost as good as saying it is outside the 10 years period stipulated by the law. That's my own opinion.
Okay. Wow, interesting. Thank you so much. So, Mr. Kosa, what's your take on this particular grant raised by the Labour Party candidate?
Well, I've listened to my learned colleague and his argument in respect of that. In generally, to lay the ground rule is that we are not trying to hold the conclusion that the court is going to hold. Yes, on this ground is a valid ground recognized by the Electoral Act. If you go to section 134 of the Electoral Act, it provides for 3 grounds upon which petition can be brought before the tribunal. The first is a person whose election is questioned as at the time of the election was not qualified to contest the election. Then the second is by reason of corrupt practices or non-compliance, and the third is majority of lawful vote cast. So this particular obese ground falls under the first condition, which we call qualification, saying that the respondent is not qualified to have even contested the election because of a previous proceeding against him. Well, to critically understand what they are trying to say, we have to make a recourse to section 137 of the Constitution. And in doing that, I will at this point disagree with the opinion of my learned brother. The beauty of section 137 is that each paragraph of 137 is disjunctive. If you have the Constitution with you, you will notice that at the end of each paragraph there is "or" on it. So the major subsections that are open for argument is subsection D and E. Permit me to read subsection D and E. Subsection D, it says that is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence on imprisonment or fine from any offences including dishonesty or fraud by whatever name called, or any other offences imposed on him by any court or tribunal or substituted by a competent authority, or any other sentence imposed on him by such court or tribunal, or emphasis on the word now, or E, within a period of not less than 10 years. If you notice that paragraph E, which was emphasized by my learned brother, is distinct from paragraph D. Paragraph E says that less than 10 years must be brought between less than 10 years. But what offense must be brought within less than 10 years? If I read it, it says within no less than 10 years from the date of the election and has been convicted and sentenced for an offense involving dishonesty and has been found guilty by contravention of the code of conduct. So in paragraph E, the element of crime described in paragraph E of one section or section 137 is different from that described in paragraph D. In paragraph D, there is no limitation of time as stipulated in paragraph D. And paragraph D falls directly, squarely on the issue that is now a front burner for the petition for the tribunal to decide. So my opinion is that it's not bound by law. There's no limitation of time in bringing this action because it falls strictly under sub D and not E of 137 of the Constitution. Thank you.
Okay. Thank you. We are not holding brief for any of this party anyway. Yeah. So that's interesting and eye-opening. Thank you. Yes, taking cue from what Mr. Paul said. You said, and there will be likelihood that that particular grant may not be able to sustain their petition. And there are other grants upon which the Labour Party or Peter Obi brought his petition to court. So we'll also look at another point, and let's see how rooted this particular point might be. And one of the points I think it's something that's also in other people's heart is the issue about the transmission of election results. And one of the questions that have been raised is that, does the action of INEC, does it totally go against the clear provision of Electoral Act when we are looking at maybe section 47 subsection 2 of the Electoral Act and section 64 that talks about how accreditation of voters should be carried out vis-a-vis regulation guideline of INEC. I think this was one of the major grounds that was actually elaborated upon in Article's petition too, if you have gone through it. I don't know, can we talk on that particular point? Because we saw that initially, one of the things, like I mentioned in my previous video, that gave hope to people to actually participated was the whole idea that there will be no need for vote buying, there will be no need for ballot snatching, because the moment results are transmitted, there's nothing you can do anymore. So the promises made by Yakubu was actually one of the reasons why a lot of persons decided to participate, but we saw that that was not really what happened on the day of election. So Mr. Paul, I don't know if you can talk about that. How strong is the whole argument about the transmission of vote? Because one of the things we later heard is that, in instances where some things are not working, the INEC has the right or the discretion to do it the way they've been doing it before, like the transmission through paper, as against the clear provision of section 47 of the Electoral Act that also advocates for what technological use in transmitting results or accreditation of voters. So, Mr. Paul, I don't know if you can comment on that. Is it a point that they can really argue upon?
For me, I feel very strongly that this is a very arguable ground, and it can go either ways. Like we actually stated from the beginning, this is not we concluding, it's just we
No,
stating
we
our
are not.
opinion based on the law as we see it. So the first thing we have to look at is it's the provision of the Electoral Act as to the manner in which the results of an election should be transmitted by INEC. So the relevant provision, if you look at section 60 of the Electoral Act, subsection 5, you come to find that the provision is to the effect that the results of the election shall, the word used there is shall, which means mandatory, shall be transmitted in a manner prescribed by the commission. By the commission, prescribed. The operative word for me there is prescribed by the commission. It's arguable anyway. Now, what was the manner in which INEC prescribed that the results of the election would be transmitted? It takes us to section 38 of the election guidelines. And when you look at that provision, it is very clear there where INEC prescribed that. I'm going to read, I don't know if I have the permission to, I'm just going to read briefly and try to summarize it. Paragraph 38 of the regulations and guidelines of INEC. So it says that on completion of all the polling unit voting and result procedures, the presiding officer shall, again, shall, not may, electronically transmit or transfer the results of the polling unit direct to the collation system as prescribed by the commission. 2, use the beavers to upload a scanned copy of the EC8A form to the INEC result viewing portal, which is IREF, as prescribed by the commission. 3, take the beavers and the original copy of each of the forms in a tamper evidence envelope to the registration area or ward collation officer. I'll just end it here, right? So if you read further, it's just a few other paragraphs there. Now, when you combine the reading of section 60 sub 5 of the Electoral Act, and then you look at paragraph 38, which I just read of the guideline, you will come to conclusion that the manner in which INEC prescribed, the commission prescribed, was that results will be electronically be transmitted from the polling unit upon
Yeah.
completion of the vote. That was what they said. In fact, there were a series of evidence or
And
public
even briefing, they
notices.
get briefings,
Briefing, yes,
several
briefing.
briefings. Yeah.
Yeah, several briefing by the INEC chairman Yakubu. He came on air several times and said they're going to follow that procedure, right?
Yeah.
So where the commission has prescribed a way, the manner in which the results will be uploaded and transmitted and all that,
Yeah.
they are not allowed to deviate or to go out of that procedure to do
Yeah.
something else. Procedural laws, even though they are meant to guide the ways things are to be done, they are meant to be obeyed. They are not something you just do because you want to play. You
Yeah.
just don't enact guidelines that you will not follow. So people have
Yeah.
actually argued, which I find to be quite reasonable, that the prescription under that paragraph 38 is not mandatory, that the Electoral Act actually provided for manual transmission of results, and that paragraph 38 rather is like a supplementary provision. I find that argument very interesting. So the question is, so why have these regulations? Why have these guidelines when you know you're not going to keep or follow it? They went on to buy these equipment. They bought this equipment with taxpayers' money, right? So that's even outside the law now. Now, given all of this fact, it is my view that the procedure of INEC must be followed as prescribed. So saying that the Electoral Act says that results should be uploaded manually, sent and all that. It is one of the ways. It is both of them are mandatory. So when you read those provisions together, why the electoral officer is mandated to transmit results electronically, the electoral officer is also mandated to take a manual form, those manual forms to the collation center as well. So they are both mandatory. The other one is not supplementary to the other. They are both mandatory because of the operative word used there as sha. So in my view, I think the Supreme Court is going to look at the intent, look at the provision of this relevant section in deciding whether INEC complied with the regulation. I'm going to leave it at that, but I feel strongly
Okay.
that INEC did not. But let me say something very quickly. There's
Okay.
a particular case that is very instructive, very, very
Yeah.
instructive in this argument. So if you look at the case of Inyama against Akpabio, reported in 2008, the court held that where there is an allegation of non-compliance with the Electoral Act,
Yeah.
the person alleging must establish by evidence that the effects on the outcome of the election was affected by the non-compliance. So,
Yeah.
much as we are saying that there was non-compliance, for the Labour Party and for Peter Obi to succeed, they are actually required and obligated to show that the outcome of the election was affected as a result of the non-compliance of INEC. So it's not enough to just say there was non-compliance. You have to
Yeah.
proceed further to show that the outcome. So that's the question that the court is going to look at. And of course, we're also hoping that the lawyers of the Labour Party are going to put forward credible evidence before the court.
Okay, I don't want to really join issue with the issue about the outcome, but nevertheless, I have availed my mind to section 47 of the Electoral Act, subsection 2, that talks about the use of technology, card reader in accreditation of vote. I think the Electoral Act, in terms of authority, even supersedes the whole regulation and guideline. But nevertheless, that is the beauty of this particular act. That is the Electoral Act 2022. Because it was what brought us out of the whole idea about manual transmission, the use of paper, traveling from one location to the other. That's the beauty of this act. And I think the lawmakers, there was an intention, in fact, a clear intention on the whole idea of the introduction of beavers, the use of technology for transmission. And I think it is clear enough. I don't even think it's left to the discretion of how maybe when it's not working. Even exigencies were even covered up for. If you cannot do this thing online, you can go offline and also do that. And like you mentioned, monies were allocated. So I don't think people come up with guidelines for phone fare, or they draw a budget just to go back on their word. I think intentions were actually clear from the beginning, and even down to the Electoral Act, the intention is very clear. So
It's
I
clear.
don't really know. But
The,
nevertheless, I will also want to hear
the,
from Ms. Promusa.
yeah.
Yes.
Well, generally, the general provision of the law is that I enjoy the argument of Mr. Paul. The general
Yes.
provision of the law is that when a law stipulates the doing of a thing,
Yes.
doing it in any other way amounts to not
It's
doing it at all.
contravened. Yes.
It amounts to not doing it at all. That is the general principle on procedural law. The issue that comes to mind at this point is the act of non-compliance with the
Yeah.
provisions of the Electoral Act. Has this substantially affected the election?
Exactly.
So
Yeah.
the argument of substantial compliance and what the substantial effects of the non-compliance
It goes to the
becomes
root of the
yes, it comes
outcome.
to the root. If you read your section 47 that you read,
Yeah.
the provision there were very clear and plain. The provision
Yeah.
is that if this technological device affects even the units, and it comes to mind that that unit, the result of that unit is substantial in the evaluation of the result of the election, the INEC
Mm.
shall cancel that election and have
Yeah.
another election within 24 hours. So if you
Yeah.
put the computation of the data all together, you will see that the non-compliance of not using the beavers and the IS portal
Goes
has
to the root of the outcome. Yeah.
substantially affected the election all through. It
Yeah.
substantially affected the election, the transparency of the results at each polling unit. So it's
Yeah.
enough is a ground that is
It's
very
enough.
weighty. But
Okay.
again, we must quickly give our rider. Improving not compliance is one of the tricky parts in election petition to prove not
Okay.
compliance because the court is most of the time court always hold the opinion that there was substantial compliance. The idea of electoral act is not 100% compliance. So long there is substantial compliance, the court will take it good. So in proving not compliance, you must argue with specificity the points or the areas where there was no compliance as alleged in your petition. So if you read the reply of APC and the reply of Tinubu to Labour Party's petition, you will see that they have distinctively argued that Obi petition lacks weight because it failed to refer to specificity. There was no
Yeah.
specificity. What Obi would have done, or what I would have expected in their petition, is that in each of the polling units where there was no compliance, there will be specifically pleaded so that
Yeah.
evidence of document.
I think Atiku did he
Yes,
did a nice
I
job on
think
that point
yes,
in his
I
position
think
in his
I think we did that better than Obi's petition. So the
yeah.
non-specificity becomes an issue of deliberation at the tribunal because after pleading there is no compliance, did you specifically prove? It's like in general procedure, it's like special damages. If you are claiming special damages, you must specially provide the particulars for you to be granted
Yeah.
special damages, unlike general damages. So in election petition, you must prove with specificity and a careful clinical examination of the petition.
Hmm.
It actually seems to lack enough specificity to substantiate the argument of non-compliance.
Yeah,
Thank you.
I think, yeah, yeah, thank you so much. I think why that may not be a strong point for the Labour Party, it was actually really canvassed on
Yeah.
Atiku's
Yes,
petition. It was really,
certainly
they
it was.
really did that. I think what the
Yes,
Labour Party did was to look at the technical aspect of it, where they pleaded the form, the back end of the, where they are supposed to get copies of
yes,
this result that was
yes.
transmitted. I think they were looking at it from different, but we await the court to see how the court or the judiciary will look at this thing. But let's quickly go to our next point. I think one of the issues that also surrounds this election quickly is the whole idea of the 25% in Abuja and in other states. I think also the PDP actually did a nice work in trying to argue on this point that by virtue of section 134 of the constitution vis-a-vis section 66 of the Electoral Act 2022, that for a candidate to be declared the winner, he has to first of all have majority of the vote cast, then 1/4 of the vote from 2/3 of the state, and 1/4 or 25% in FCT. So a lot of persons are arguing as to, oh, should we include FCT as part of the state, or that 25% has to single-handedly come from FCT, while you can get 25% from 2/3 of the state. I think if I remember my state and capital correctly,
Yes, 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 yes. Yes.
FCT has never been seen But
as a
I
state.
don't know. What do you think? Let's hear from Mr. Ekponsa first. Then I will hear from Mr. Paul. Mr. Ekponsa, how do you view this argument?
I actually did a video with regards to this argument, and it actually went viral, and there were a lot of feedback from the video.
Yeah.
Well, the issue of 25% in Abuja is still a front burner. It's still one of the issues erected for the court to decide upon. In my own personal opinion, we have to go back to that session and do a personal reading of that section 134. I'm of the opinion that the use of the word "and" there distinct the other states from FCT. It says it shall have not less than 1/4 of the voters in 2/3 of the states in the federation and the Federal Capital Territory Abuja. So I'm of the opinion that the use of the word "and" at this point we will have to use interpretative principles. If you check the mischief rule at this point, what was the intent what was the mischief that the draftsmen were trying to cure at this point? And what the draftsmen, in my opinion, what the draftsmen were trying to cure was that in order to show widespread acceptance of that candidate, after winning 2/3 of states in Nigeria, that same popularity should also be tested in the capital territory of the country. So I'm of the opinion that the use of the word "and" then distinctively separates the 2/3 of the states as mentioned and the FCT. It does not it did not say including FCT. So the language used in that particular section becomes a subject of interpretation in this particular petition, and we are all waiting to see how the court will interpret it. That is my opinion
Yeah,
there.
yeah, thank you. So I really want to ask, does it go to the root of the whole procedure or the election? Let's say paraventure.
Yes, it does. It also forms part of non-compliance.
Okay.
Because apart from the electoral provision, this is constitutional requirement.
Yeah.
So it's very rooted, it's very fundamental. It is very
Okay.
basic to the determination of the petition.
Thank you so much. So, Mr. Paul, how do you see Section 134 of the Constitution?
Like Mr. Peters said, this is one issue I am very, very, very interested in its
Yeah.
outcome. I want to see what the Supreme Court is going to rule on, right?
Yeah.
Okay, so I'm a bit restrained, right, to toe that line of argument. A bit restrained, and I'll tell you the reason why. So, Section 134, which is the section that talks about which Mr. Peters actually cited. So I'm not going to go through it again because I think he has already read it. That section should be read together with section 299 sub 1 of the Constitution. So when you look at section 2991 sub 1 of the Constitution, you come to see that the FCT was regarded as one of the states of the Federation. It means that FCT is the 37th state of Nigeria, so to say, and that of course goes against what we were taught in school that 36 states are capital. So what that section provides is that the provision of this particular provision shall apply to the FCT as if it were one of the states of the Federation. Now, if you look at one of the cases that was decided on me, the case of Baba Panya against President, very funny name, President of the Federal Republic of Nigeria, reported in 2018, the court held that it is therefore doubtlessly clear that by virtue of section 299 of the Constitution of the Federation, the FCT is in law a state. In other words, the FCT should be treated as one of the states of the Federal Republic of Nigeria. So, quickly, what I'm trying to say here in essence is that Section 134 should not be read in isolation. It should be read together with Section 299 sub 1 of the Constitution, which provides to the effect that the provisions of the Constitution shall apply. Note that the provisions of the Constitution shall apply to the FCT as if it were one of the states of the Federation, which of course goes against what we were taught in primary school, 36 state and capital, right? But for purposes of the Constitution, the provision of the Constitution, the FCT is regarded as one of the states of the Federation. Now, in the case of Ibori and Ogboro, the court also said that the FCT is not to be treated as being superior or inferior to any state of the Federation, meaning that it has the same equality, Now that brings me to what I feel, right? This is my personal opinion and may not be the decision of the court. So I feel that if we say that a presidential candidate has to score 25% in FCT, even if he scored 90% in the entire 36 states, wouldn't that amount to making the FCT the electoral college? And I feel if you're going to give that if you're going to interpret that section 134 to mean that you must have 25% in FCT, I feel it's going to be to amount to and for me an anomaly, which the Supreme Court has said that the constitution should never be constructed or construed to be an embarrassing anomaly. So the Supreme Court has said that you approach the construction of the Constitution liberally, like you look at it in a more liberal way and not in a way that you want to restrict it. So my argument, my point is that I strongly feel that this is going to be a very, very arguable ground for both parties. I am from where I'm sitting, I feel for PDP they might be able to sustain this argument if they can be able to convince the court that the word and shows that it makes the FCT a standalone. But if APC were able to show the court all of these that I've just said, it might go either way. But let me say that the problem about this section is, for me, is poor drafting, right? The draftsmen could have saved us this controversy if they had gone further to say and in. If they had added and in, that preposition in changed this whole argument. So, but when they say and, so it can either go either. The people will argue that though it is conjunctive, it can be means that it is both. You have to say 24 states plus FCT. It is not 25 states and you must have 25% in FCT. So it's a very, very good, for me, I'm happy that the Labour Party raised this issue. I think PDP did as well. And
Yeah,
actually, yeah,
in fact, it
yeah,
stressed on it more than the Labour Party.
yeah, exactly more than it. Yeah. So for me, I'm actually happy that it's going on, and let's see what the Supreme Court will. But it's very instructive. Oh. Let me draw
Yeah.
our minds to something that there was a kind of an attempt by the court to touch on this issue, but the court did not deal on it expansively. In the case of Buhari against Obasanjo, this section 134 fell in for consideration by the court, right? So the court heard that the purport of the provisions, which is that section 134, is simply to ensure that a winning candidate should have the required majority. The court stated further that once a candidate attains such majority, the requirement of the section is fulfilled. The court didn't look at the issue. In fact, I can give you the citation. Buhari against Obasanjo reported in 2005, All Federation Weekly Law Report, part 273, right? I actually feel the Labour Party and the PDP, they're going to struggle a bit. However, I believe the lawyers are very smart. I believe they can argue, look at that provision properly. Like Mr. Peters has said, they might be able to come up with, maybe able to sustain that ground.
Interesting. We will look at what the court will actually decide. Like they say, the judiciary is on trial. So let's just see. Yeah, because it will actually serve as a strong precedent after now.
Yeah.
So we'll look at what the court said. So quickly, I know before we wrap up, let's quickly touch on our last point. So one of the points also raised by the Labour Party is the whole idea that by virtue of the fact that the vice president candidate of the APC, that as at the time he was nominated as a candidate for the APC, also a senatorial candidate for Borno
Center.
And
Yes, center.
by virtue of that, it invalidates their involvement in the election and also cancels whatever vote they got during the election. So I don't know how you look at this point. I know that you cannot hold two positions at the same time or be
Yeah.
contesting for two positions at the same time. But what do you think? Does the irregularities surrounding the vice presidential candidate, does it really have any stronghold in this whole legal battle or petition?
Yeah. Thank you. For me, I feel this is where both the PDP and the Labour Party are going to get the APC. This is one ground that I feel strongly that they are going to have a field day, getting at the APC. So, first of all, we have to establish something here that,
Yeah.
like you rightly stated, no
Yeah.
candidate, by virtue of the Constitution, is actually expected to run for two different positions, right? You cannot be a candidate of a senatorial election and at the same time be a candidate of the vice presidential election. It is not allowed, it's prohibited. Double nomination is prohibited expressly by the Constitution. That is a given. And you look at section 134 sub 4, right? And
Yeah.
section 142 sub 2 of the Constitution. Now, the issue
Yeah.
is, was the vice presidential candidate of the APC, was he running in both Boronu and the VP together? That one is a fact that needs to be argued. But however, they've said that he signed his nomination form for VP on the 14th of July 2022, right?
Yeah.
2022. And then he now withdrew his nomination for his candidacy in the senatorial election of Borno Central on the 15th of July, which means that as at 14th of July, when he signed the nomination form for the vice president, he was still the senatorial candidate for Borno Central constituency. So those are the facts that will be argued, however, right? But the law, let's look at the law. The law is that a candidate cannot stand for an election in two different constituencies. And
Yeah.
the law is clear that for purposes of the vice presidential election, the whole federation is regarded as one constituency.
Okay.
So
Yeah.
exactly. So for senatorial election, it is by district, right? So if a candidate is running for both senatorial and vice presidential at the same time, of course, that's a clear violation of the law. But now, does it go to the root? Does it disqualify Tinubu? I think that's even the germane question. The
That
answer
is
is yes.
the issue because
The answer is yes.
okay.
Go ahead.
Yes, Mr. Paul, you were saying, does it really affect the voting by Tinubu? So
Tinubu,
you
yeah.
want to respond?
Yeah. Yes, it is. Once the Supreme Court comes to the finding that the vice presidential candidate, or rather the vice president elect, because now elect, had double nomination at the time he filled his nomination form for the VP position. It goes to the eligibility of Tinubu to contest that election. Now, how? So you know that, like you said, it's the Nigerian practice, a party form of system where individuals really don't contest the election. It is a party. However, it is a joint ticket. The president and the vice run on a ticket. So where the vice is disqualified, it affects the president. And this issue actually came up, though it was recent, but I think it's a little bit old. If you look at the case of PDP against ZG, is a Bayelsa
Yes, yes,
gubernatorial election. Yes,
the Lions case.
exactly.
Yes,
So, though the disqualification of the deputy governor was not on the ground of double nomination, right? It was on the ground of
yes, yes,
irregularities regarding names and all that. But
yes.
however, it touched on the issue of disqualification of the deputy governor.
At the joint ticket, the principle was
Exactly, and the
made.
joint ticket. Yes, and the joint ticket. So where the deputy or the vice president, whoever it is disqualified, it affects it vitiates the qualification of the principal, whether the governor or the president.
Yes.
It has been decided. It's a decided case. So, but now the issue about party, it all goes. They're all thrown out of this thing. So in that case, when the Supreme Court heard that disqualification of the deputy governor automatically vitiates that of the governor, APC lost the election. In fact, APC was removed. PDP are now the ones ruling by assets at the moment. So it's not a question of party now; it's a joint ticket. So if the Supreme Court comes to the conclusion based on the available fact presented that Shettima was not qualified as a result of double nomination, right? It will vitiate the qualification of Tinubu to become the president of Nigeria, and that's the authority. PDP against the authority for that.
Well, that's interesting. Thank you so much for that wonderful submission.
Yes. My point on it is that first, the issue has been raised as pre-election. The court has heard that another party cannot probe into the activities of another party when it was raised by PDP and APC against the same Shettima. So the question now first is that at this point now, can that same pre-election matter emanate and transform into an election matter? Okay, first of all, this issue of Shettima's qualification was raised as a pre-election matter by Atiku and PDP. And the court ruled on it, saying that PDP cannot probe into the activities of APC, that it is the internal affair of APC to decide whether or not it was. So at this point, now raising it again in the election petition, the question that comes to mind is that can the pre-election matter transform itself into an election matter? The question on that is no. The pre-election and election petition are separate proceedings. Though there are some pre-election matters that can be entertained in election petition, but this particular issue is beyond the one that can be entertained in election petition. So looking at the legal point of it, though it's a valid argument made by Mr. Obi and the Labour Party, but the court may, I'm of the opinion that the court may, yes, it was majorly raised by the PDP. They even litigated on it as a pre-election matter. The court may be of the opinion that being that it was not challenged within 14 days by any APC member as provided by Section 289 of the Constitution within the jurisdiction of pre-election, it has been terminated. You can't resurrect such issue at the petition at this stage. And if that is the case, the argument and all the grounds and all the particulars raised on that ground collapse automatically. So it's for the tribunal to decide whether it is a pre-election matter or it can also transform into an election petition.
Is it
if you look at Section 31 of the Electoral Act and Section 35 of the Electoral Act, so Section 35 provides for double nomination. But if you see the defense of the APC, their defense is that, yes, Shettima actually wrote to the party. It was the party that failed to convey to INEC. If you read Section 31 of the Electoral Act, the duty of the candidate is to write to the party and not to INEC. So following the argument of APC, Shettima actually complied. It is the party that failed to comply. That Shettima actually wrote to the party within the time required. But it's the party that now failed to transmit his resignation as candidate of the Borno Central Senatorial District. So now they shifted the burden away from Shettima and placed it on APC to show that Shettima itself resigned. So it's for the court to look at all of this.
So I don't know if I can say something. Just a point.
You can.
Right. Okay. So I agree with Peter's on the issue of fact that this issue has been litigated before, right? So, but it's also a constitutional provision.
Yeah.
Right. Exactly. So it is not left for the Supreme Court to say it is a pre-election issue since it falls within the purview of the Constitution and goes to the qualification of Shettima, it can be tried at the Supreme Court at that level. So I feel it's something that I strongly believe that the Supreme Court is going to consider it. I strongly believe so. They're going to consider it. Then so the issue of the defense, I read it and I was laughing. Right, the defense, the defense they are trying to put forward that he submitted his resignation letter, they did not submit it. For crying out loud, right? Shettima is not running on his own. It's a collective obligation. So if you say that party failed to submit his resignation to INEC, the question is exactly. So if
exactly.
exactly the point.
Yeah.
Exactly the point. So the party will be penalized. And what happens if the party is penalized? What happens to the candidate? So the question
It's the
is
party
actually
that
I feel
sponsors the candidate.
exactly that sponsor the candidate. So if the Supreme Court is going to hold that okay, you fail to to submit
They are
your resignation
admitting
letter
and
to
shifting blame at the same time. It's somehow.
exactly. So I
Yeah.
think this one that's why I said earlier on that this is one area I feel the Labour Party and the PDP can really get the APC because from the from the body language, from the mood, you read the mood of the APC, the body language of APC, they know that is one area that if they are not careful, they are going to get shot. So that's why they are now approbating and reprobating and trying to look for a defense.
Now,
So
the
for, for
consequence of
me, I'll
this
push
is
it.
that if they go with Labour Party, that will mean that because Labour Party is asking for another election, that will mean that the APC and its candidate will not contest in the other election.
Exactly.
Mean that
So,
they don't have the qualification to even contest. So it will not be between PDP
and Labour Party.
and Labour Party. The reason why it has to be like that is because Atiku has not satisfactorily satisfied the provision of the electoral to be so declared the winner.
Exactly.
So there has to be another election between Atiku and. So it's a very technical point that was raised as
Yeah.
a qualification. Qualification is the major strength of the petition. If the qualification goes in favor of APC cannot contest in the other election that is to be contested because the time allowed for nomination of candidates has long expired. So they cannot bring in fresh candidates. Their candidate is already disqualified by reason of not having the requisite qualification to contest in the election. So that is the point.
Wow. Thank you so much. This is the beauty of the law. And it's an interesting one, and we look forward to what the court will rule because it will definitely set precedent for a lot of things, and we hope
A lot.
we hope that the court will do the right thing and do it in accordance to the law. So, ladies and
Yeah.
gentlemen, thanks so much. And I want to specially appreciate our guest, Mr. Ike. Thank you so much, Mr.
Thank you.
Paul.
Thank you.
I am most grateful. This was quite insightful and interesting. I like the way the points were argued and talked on, and it was quite interesting. So, ladies and gentlemen, thank you so much for listening. Do not hesitate to like, comment, and subscribe. Do you have a dissenting view? Why not leave a comment below? And thank you so much. See you another time. So, bye.